Case study: Routledge vs. Grant 1828. Introduction. Routledge vs. Grant 1828 is a landmark English contract law case that centers around the concept of offer and acceptance, specifically addressing the timeframe for acceptance and the potential for revocation before acceptance is communicated. It clarifies that an offeror retains the right to withdraw their offer before it is formally accepted by the offeree. Facts of the case: Mr. Routledge, the owner of a house, wrote to Mr. Grant, expressing his interest in selling the property for £650 and specifying that the offer would remain open for 6 weeks. Within the 6-week period, but before formally accepting the offer, Mr. Grant informed Mr. Routledge that he had changed his mind about purchasing the house. Subsequently, Mr. Routledge received Mr. Grant's formal letter of acceptance within the 6-week time frame. Issues: Was Mr. Grant's change of mind before formal acceptance a valid revocation of the offer, rendering the subsequent acceptance ineffective? Did the 6-week window specified in the initial offer bind Mr. Routledge to keep the offer open even after learning of Mr. Grant's hesitation? Can an offeror revoke an offer at any time before acceptance, or are there exceptions based on timeframe stipulations within the offer itself? Decision. The Court of King's Bench, by a majority decision, ruled in favor of Mr. Routledge. They held that the 6-week period simply outlined the duration Mr. Grant had to consider the offer, not a guarantee against revocation in the interim. Mr. Grant's communication of his change of mind effectively revoked the offer before Mr. Routledge received the formal acceptance letter. An offeror has the right to withdraw their offer at any time before acceptance, regardless of timeframes mentioned within the offer itself, unless bound by a formal contract or estoppel. Significance of the case. Routledge v. Grant established a cornerstone principle in contract law: an offer remains revocable until it is accepted, irrespective of any stated timeframes within the offer itself. It emphasized the importance of timely communication when accepting an offer to avoid the risk of revocation. Clarified that an offeror retains control over their commitment until acceptance is communicated, even if they initially suggest a longer timeframe for consideration. Reinforced the concept of mutual agreement. A contract is formed only when there is a meeting of minds, offer and acceptance, and either party can retract their commitment before that point. Elements of contract formation. For a valid contract to exist, certain elements must be present. Acceptance, a clear and unconditional acceptance of the offer by the other party. Consideration, something of value exchanged between the parties: goods, services, money. Intention, to create legal relations. Both parties must intend to be legally bound by the agreement. Applying Routledge vs. Grant to other cases. Cases involving counter-offers, negotiations, and potential revocations within complex communication chains often draw parallels to the timing considerations in Routledge v. Grant. The use of electronic communication methods, such as email and instant messaging, has led to legal discussions about adapting the principles of acceptance and revocation to the nuances of digital communication. The case remains a key reference point for understanding the power of timely communication. The potential pitfalls of relying solely on stated timeframes within an offer. Conclusion. Routledge v. Grant serves as a reminder of the critical role of prompt acceptance in securing a binding contract. It underscores the importance of understanding the offeror's right to revoke and emphasizes the need for clear communication throughout the offer and acceptance process. While seemingly technical, the principles explored in this case have practical implications for anyone entering into any kind of agreement, from everyday transactions to complex business deals. If you are a law student and looking for more case studies, visit our website www.mylawtutor.net.